Yeah, I thought he was going to leave and come. He's like, I'll be back. But I see he's like, no, Lindsay will do it. Hello. Court is calling 2025 CR 001529 State versus Tony Rodriguez. Can I have parties announced?
Lindsay Shaw for Mr. Rodriguez.
And are you Mr. Rodriguez? Counsel, have you received all discovery and was it reviewed with Mr. Rodriguez?
Ma'am.
Court will find that the state is in compliance with discovery. Mr. Rodriguez, did you review the application for community supervision with your attorney? Did you understand it and sign it? Did you review the true bill of indictment with your attorney?
Yes.
Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
No, Judge. Waiving count 1 and waiving the habitual offender enhancement allegation.
No, Judge.
Right. Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged in count 2 with
V1. Okay, hold up. Before we dive in, discovery just means the prosecution handed over all the evidence to the defense. Think police reports, witness statements, the whole kit. And when the court says they're in compliance, that means no one's playing hide and seek with the evidence. All clear.
possession of a controlled substance, penalty group 1, 4 to 200 grams as a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine.
Yes.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call in the right to remain silent. By entering this plea, you are giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, ma'am.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, ma'am.
Mr. Rodriguez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
Oh, ma'am.
Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, the state is proceeding on count 2. Punishment is to be assessed at 10 years in the prison. The state recommends community supervision. They're taking in consideration 2024 CR 009421, 2025 CR 002257. Did you understand that to be the plea?
Yes.
Defense?
Yes, ma'am.
State?
Yes.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
Did you understand by signing this, you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 5 years. Did you understand that was a recommendation from the state and the court does not have to follow those recommendations?
Yes.
Then to count 2, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State, any evidence?
Contained in Exhibit 1 and attachments.
No objection.
All right, state, you may be excused. I'm sorry, do you have the dismissals?
I do.
Did you review the waiver and stipulations with your attorney? Did you understand it? Thank you. And sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses? The state will call in the right to remain silent.
Yes.
Did you understand that today the state will be
This is huge. The court's making a legal sanity call right here. When a lawyer says the defendant was legally sane at the time of the offense, they're confirming he understood right from wrong. That one sentence can be the difference between prison and a mental health facility.
presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states Exhibits 1 and attachments, and the court will review the same.
7 days.
All right, after reviewing states Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, ma'am.
Anything you wish to say on behalf of your client?
Judge, I would just like the court to know, since I met Mr. Rodriguez, he has since voluntarily put himself through an inpatient lifetime recovery program. He completed 47 days. He brought proof of his certificates to court today. He was released on June 23rd, and just the difference I've seen in Mr. Rodriguez from the first time I met him. I met him when we first met. He was in custody, and he has since been able to bond out, put himself through lifetime recovery, and he's doing quite well. So I think he's anxious to prove to the court that he's going to complete probation and be successful.
All right. Are you employed?
Not right now.
All right. So are you still in lifetime recovery outpatient? What are you doing?
I gotta.
Boom, he pleads guilty. But don't miss the nuance. The judge just warned him. Even if there's a plea deal, the court doesn't have to follow it. Judges have the final say. Ever wonder how many people take that gamble?
We're on the 3rd at 8 a.m. and then just the 90 days for as of right now.
So you're still there?
No, I'm up here. I still gotta go set up for outpatient.
Okay. All right. And who is Stephen Shelby?
Friend of mine.
All right. Just a friend?
Yes.
So you're not related. Do you have any children?
Yes.
What are their ages?
25, 21, and 20.
And do you live by yourself or you live with
For
someone?
my grandmother.
All right. Who all lives in the household? Any minors? And if you're drug tested today, what are the results going to be?
Was even 5
For what?
for men.
So you still have a lot of work to do.
I got.
Well, here's the thing. Nobody can help you if you don't reach out and if you don't help yourself. Lifetime recovery is a good program, but they can't give you tools and then you're just like, I'll take the meth, you know?
I understand.
All right, this is what the court is going to do. The court is going to sentence you to 10 years in the prison, suspended and probated for 5 years, regular reporting by Zoom or in person.
Now here's where it gets real. Voluntarily going into a 47-day inpatient recovery program shows initiative. That's not a small step. It's a legal strategy and a redemption arc rolled into one. But is it enough to sway the judge?
There's to be no contact with Stephen Douglas Shelby. There's to be no residing with minors. I want a referral to felony drug court. TAP evaluation out of custody. Follow TAP recommendations. There's going to be 120 sober meetings in 120 days. Proof of employment within 30 days. No employment as a home health care provider or with minors. Field visits 1 time per month until further notice. Probation is, taking consideration 2024 CR 009421, 2025 CR 002257. Probation, is there anything else? Stephen Douglas Shelby. And there's going to be 200 hours of community service restitution. You need to be kept busy. You understand? Anything else, probation? Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it?
Yes.
And did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. This is a felony conviction. You're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
I understand.
All right, we can go off the record. Here's the thing. I've had people who've come in here before, and you could tell they're extremely high. I don't know when the last time you used meth, but what I do know is only 1 or 2 things going to happen if you don't get this under control. Either you're going to end up in somebody's jail, somebody's prison, or either somebody's going to have to identify your body. Here's a suggestion. You should probably go back to Lifetime and tell them you need to be in their inpatient treatment. One thing about drug use, you got to change people, places, and things. And obviously, being at your grandmother's house, it may not be the environment inside your grandmother's house, but it may be the environment that's around her home, and you cannot resist temptation. You understand?
I understand.
So I'm going to refer you to felony drug court. You need to be 100% honest with them, and they should probably be able to accept you into the program by next week, hopefully.
Great.
All right. But call Lifetime Recovery and tell them you need to be back in their inpatient treatment program. All right? And if there's anything you need from the court, we're here to help you, okay?
I understand.
Thank you.
Thank you.
All right, good luck to you. Thank you. You are constantly in trial or somewhere.
I am somewhere.
It's the never-ending trials. All right, so where are we?
Your Honor, we have come back where my client's been found competent.
Yes.
I've reviewed the plea bargain with him today. I reviewed, that he's going to be asking the court to follow the plea bargain and assess the 2 years.
So have you all done paperwork?
Yes.
Oh, okay. The problem is I don't have a file stamp. That's why. I'm sorry, could I have a file stamp? Oh, no problem. I didn't know this was for a plea.
And Your Honor, if I can clarify, it is just for the sentencing.
Yes.
The plea's already gone through.
Yes.
That is so true.
Yes.
He's previously been, and then there was an issue, maybe.
Right.
Okay. All right, the court is calling 2024 CR 011984 State versus Daniel Montoya. Could I have parties announced?
Ashley Jones for the state.
Arlene Gay for the defendant.
And are you Mr. Montoya?
Yes, ma'am.
All right, this is what I'm going to do. I know that previously we had the plea, and then there was some question of maybe he's not competent.
Correct.
So I think it would be best, so that the record can be clear, we will just do the entire plea over again as far as me going over his rights with him, because now it's 100% certain that he is competent.
Okay. I think that's fair.
All right. I'm sorry, can I have a file stamp back?
Yes.
And it's just so that we can make sure that the record is clear, okay? And what I can tell you, whatever plea bargain agreement that you all had previously worked out, I know that I was intending to follow it until we stopped in the middle of the plea, okay? All right, court is calling 2024 CR 011984 State versus Daniel Montoya. Could I have parties announced?
Ashley Jones for the state.
Arlene Gay for the defendant.
And are you Mr. Montoya?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes.
Court will find that the state is in compliance with discovery. Mr. Montoya, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
All right. Counsel, do you waive the reading of the indictment?
Yes, we do.
All right. And I do have an application for deferred adjudication, but he is not applying. Is that correct?
That is correct. We are asking the court to sentence him to the 2 years, and I've discussed this with him multiple times, discussed it with him today, and that is what he wants to do.
All right.
Is that true?
Yes, ma'am.
All right. Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
All right. You're charged with aggravated assault with a deadly weapon. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand? Word again. So right now, what I'm going to do is I'm going to tell you what your rights are, and I want to make sure that you know what your rights are. So do you understand that you have a right? Let me go back a little bit. Here you go, counsel. Do you understand that you're charged with aggravated assault with a deadly weapon?
Yes, ma'am.
All right. The range of punishment for that is anywhere from 2 to 20 years in prison. Do you understand?
Yes, ma'am.
And it's up to a $10,000 fine.
Yes, ma'am.
My understanding is that you've reached an agreement with the state for 2 years in the prison. Is that correct?
Yes, ma'am.
I don't have to follow that agreement. Do you understand that? No. Here's the thing. No. I want you to listen, okay? Breathe. All right. I don't have to follow that agreement. So let's say I don't follow that.
Did you catch that? No contact with Stephen Douglas Shelby. Judges don't hand those out lightly. That's a red flag about who might be influencing this defendant's behavior. And keeping him clean could mean cutting ties entirely.
Agreement, and I say I want to give you 3 years, right? Not saying that's going to happen, but let's use that as an example. If I were to do that, you can withdraw your agreement and say, well, we don't have an agreement because I agreed for 2. You understand?
Oh, yes, ma'am.
All right, so that's what I mean. So I don't have to follow your agreement. If I don't follow your agreement and I try to give you more than 2 years,
I'm going to say no.
you're going to say no, right? Yes. All right, so you understand that.
Yes, ma'am.
All right, you have a right to a jury trial. So 12 people would sit on the jury. The state would have to present their evidence. They would call witnesses, and your attorney would get a chance to question them. All right. You also, the state couldn't turn to you and say, hey, now we're going to call Mr. Montoya to the witness stand. They wouldn't be allowed to do that because you have a right to remain silent. Do you understand?
Yes, ma'am.
All right. If you enter into this plea bargain agreement, you're giving up those rights. So what that means is the state is not going to call any witnesses. You understand?
Yeah.
And that means that if somebody wants to call you to testify to something, they can, because you're saying you're not going to remain silent if somebody wants to ask you questions. Do you understand?
Yes, ma'am.
Now, by entering this plea, you're agreeing to all of that. Do you understand?
Yes, ma'am.
And do you agree to all of that?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, he has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, I do.
And did you have him evaluated for competency?
Yes, I did.
And the results?
He was found competent.
Okay. All right, Mr. Montoya, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than this plea bargain agreement?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 2 years in the prison. There's a $500 fine. There's an affirmative finding of deadly weapon, and there's an affirmative finding of family violence, and there's no application for deferred adjudication. Did you understand that?
Yes, ma'am.
Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition? And did you understand you're not allowed to be designated as primary custodial parent? Did you understand that to be your plea?
Yes, ma'am.
Defense?
Yes.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? This paragraph.
Yes, ma'am.
Did you understand it and sign it in both places?
Yes, ma'am.
All right, so by signing that, what's happening is you're giving up your right to appeal. Your
Okay.
right to say, you know what? I don't like that deal. Now that I've had a chance to think about it, I changed my mind. You're giving up that right. You understand?
Yes, ma'am.
Now, there are certain things that you can still say you want to appeal on. For example, if your attorney has filed some sort of pretrial motions, I've heard it, I ruled on it, you can still appeal as to that. Do you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, there has not.
All right, then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence.
State would offer State's Exhibit 1 and all attachments.
No objection.
And state, have you spoken to the complainant?
Yes, Your Honor.
All right, state, you may be excused.
Thank you, Judge.
Did you review the waiver, this packet with your attorney? It has the police reports and everything in it.
Yes, ma'am. She did.
All right, did you understand it and sign it?
I think I did.
All right, so let me show you. Is that your signature?
Yes, ma'am.
Okay,
Your Honor. If the State may just make a comment.
sure.
On the previous plea that we did, the State waived count 2. I forgot to go through that again.
All right, okay, thank you.
Yes, Judge.
Any objections to
No.
count two?
No objection.
All right, so again, you have a right to a jury trial. Right for you or your attorney to question any witnesses the state would call, and the right to remain silent. By entering into this plea, the state is going to give me evidence on this case, but that evidence is going to come from police reports and witnesses' statements. So nobody's going to come in and testify. I'm just going to read this document and see if there's enough evidence in here to find you guilty beyond a reasonable doubt. Do you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
We're just asking the court to follow the plea bargain and also that time and money run concurrent.
All right, so with regards to the parties involved, they appear to be all related.
Yes, a brother and a sister.
So there may be a need for no contact. What's going on with that?
That was the problem with this case initially on bond, is that he lived with his grandmother a bit. His brother and sister lived I think they're allowing 1,000 feet,
Mhm.
and they live within that 1,000 feet. But I believe from just discussions that everybody's kind of made up, Your Honor, he will go back and live with his grandmother. My client is mentally ill, and so that's who kind of takes care of him, and they take care of each other.
All right.
And the sister who was involved and the brother, they've spoken to the district attorney's office. So,
All right. In state, with regards to the no contact, are you requesting no contacts or no?
The state is requesting a no contact, Your Honor. Understanding defense counsel's position, but this was a case where a deadly weapon was involved. So I will proffer to the court that at least, you'll give me one moment, the complainant with the first name of John has informed us that he wants a no harmful or injurious contact order. I don't have what the complainant...
This is what you call a compromise. Instead of total no contact, the court opts for no harmful or injurious contact. Basically, you can be near each other. But one wrong word and boom, back to jail. Risky move or necessary leniency.
Ramona would want, but she did recant.
she's been very vocal, to say the least, in favor of trying to assist her brother as opposed to assisting the state.
That is correct, Your Honor.
And they don't have parents, so grandma is the person in their life, and I think no harmful or injurious would be appropriate, because without him being able to go live at grandma's house, he doesn't have a place. And this case kind of proved it when we were trying to get him out on bond, and he had no place to go. And they put him in Lifetime, and he did do the program at Lifetime Recovery. We assisted him with his mental health and also assisted him with alcohol addiction. So he did complete the Lifetime Recovery program during the pendency of this case.
All right. This is what the court is going to do. The court is going to find you guilty. There's an affirmative finding of family violence, an affirmative finding of deadly weapon. There's a $500 fine, time and money run concurrent. There's to be no harmful or injurious contact with Ramona Montoya and John Montoya, and the court will recommend the therapeutic community. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right. When you were, yes. Oh, thank you so much. 2 years prison. You would go off and they would say, there's no term. So you're sentenced to 2 years in prison. All right, so we can go off the record. Mr. Montoya, when you're released, it's probably best for you to go to the Center for Healthcare Services, make sure you have your medications, whatever you need. And if there's an issue, if you don't have a place to stay, when you're released, if I am still here, I will make sure that I find a place for you. Do you understand?
Yes, ma'am. I stay at Heaven for Hope.
Okay. All right, good luck to you, okay?
Thank you, ma'am.
You're welcome.
Let me give you your this is your certificate, okay? And